Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we'll ask what controls employment standards legislation or collective agreements from a union. And first of all, we'll note that collective agreements are often referenced in employment standards legislation, whether it's employment standards codes or employment standards acts. They do make reference to collective agreements and the particulars that are applicable to collective agreements. And as such, the recognition allows certain latitudes for collective agreements within the framework of employment standards legislation. Nevertheless, the intention is that employment standards legislation sets forth the absolute minimums. It is a threshold below which no agreement, no party can go. As such, a collective agreement can put forth aspects that are above the minimums and that are more beneficial to union employees. However, what they cannot do is contractually attempt to give union employees something less than what is provided for in the employment standards legislation. This is against public policy, and in most such legislation, it precludes this from taking place. As such, employment standards legislation still controls and is the highest form. And even though it looks to the unions and their grievances processes and their arbitration processes to resolve matters, where the union system does not facilitate that resolution, and should it not allow for the employment standards legislation to facilitate itself to arrive at the minimums that are required, then it is possible to go outside of the union's mechanisms of grievance and of arbitration and pursue, either with employment standards or with the courts, a resolution that effectuates the protection of the unionized employee. Thank you.